to our 131st webinar. This is more on a talk on the recent developments and the recent issues happening in the court on a very important point. So Natarajan sir, as well as Krishnanand sir, and joined by several other esteemed uh, speakers of our group will be taking through this session. So it is good to have all of you back for our wonderful webinar session. And like always, this session is again going to be a very interactive session. We can all give our inputs at the end of the talk. So let us try to keep this session more interactive, and so that we can all come up with our own views on the given topic. So I once again welcome everyone who have joined us this evening. And over to you, Natarajan sir. We can start with the proceedings.
Okay. Today we have Mr. B.V. Kumar, former member of CBIC. So we welcome on behalf of Madras Tax Bar. And we have various eminent personalities.
Thank you very much.
Yes, sir. We have various personalities today with us, and our own members and department standing council, especially DRI standing council is also with us. So the digital still image camera has gone up to the Supreme Court, and when we are taking a snap in one after one case, the Supreme Court has came up with the ruling that the DRI cannot do anything further, and they have adjudicated by saying that they are not proper officers. So one of the landmark judgment or a thought-provoking judgment. So we are going to analyze by our members. I think Mr. Natarajan will initiate the discussion, and one after him, the other members also we can follow him. So I request Mr. Natarajan to initiate the discussion.
Good evening to all the friends. We are deeply honored by the presence of two eminent personalities today. One is Mr. B.V. Kumar. He has retired from the service in 1992 and he joined the service in 1958. So you can imagine. So it is almost 30 years since his retirement, and he is one person who is very active. And if you see his tenure, why I have specifically invited him to join today is, if you think of DRI, you can't. It is quite natural that we also think of Mr. B.V. Kumar. He has held the charge of DRI for quite a long time, and he had the privilege of being engaged in so many encounters and investigations and all. And he is the person who arrested even Dawood Ibrahim. So he will be having, he has written a book recently. I have read it, and for this session, I have read the book once again also, The DRI That Dawns, which will be like a Bollywood movie, a thriller kind of a thing, his experiences and all he has shared. And there can be no better person to interact with us on this particular topic. We also have our son of the soil, I saw his name, Mr. Venkatraman, ASD has also joined. So how I have planned this session today is, maybe for an half an hour, I will just go back to the entire basics of the issue, starting from the beginning and leading up to the Supreme Court decision. And I will tell my views, and then I will invite others also to join and share their views. So I have to honestly confess, till this judgment has come, personally for me and many of you also, we have not gone much deep into this particular issue. The Mangali impulse is a magic word. You have any DRI case pending anywhere with any authority, you just utter the word Mangali impulse, the matter will be adjourned. We are happy, everybody is happy. But what is there in Mangali impulse? What is there in it? So most of the people like me, it may be an understatement also, many of the people would not have gone much into the details of what are all the sequence of events that has happened. So what I thought, I will just capture the past development leading up to this particular decision, and what are all the doubts that are still remaining in our minds, and what will be the future course of the events. So like that, I will be dealing with it for almost half an hour, and then we will proceed with our discussion. First, I will invite, after this deliberation, I will invite Mr. B.V. Kumar to share his thoughts, and then we can move on to others also. This DRI was started in the year 1953. At the time, the name was Central Revenue Intelligence Bureau, CRIB. The purpose was to create a nodal agency, because At that time, you can imagine, today we have so much of communication and we are able to meet throughout the country through this Zoom platform, which was nothing that even phone may not be there at that particular point of time in an effective manner. So to bring in a national agency to coordinate at different places, at a national level agency, it was planned. A small unit was formed, one assistant commissioner and two superintendents. Initially, they were collecting intelligence, passing on to the regular customs commissionerate, and they were also given the job of taking care of the internal vigilance. That is, any corruption complaint within the department, that was also given to the CRIB, and mostly they were doing that particular job only. But within few years, they realized how it is important to set up a national agency to take care of the entire government of operations, because the role of 1957, this DRI has come into existence as an independent unit, and thereafter it has started a lot of zonal units, regional units, and now it has spread its wings almost throughout the entire country. So they have a multifaceted role of taking care of the smuggling, not only about the gold, silver, and other articles, weapons, narcotics, and they have a national security angle in the sense of smuggling of arms and ammunition. Wildlife has to be protected. So these were all the initial functions. The focus of the DRI was on that. And slowly, when the industry has opened up, the economy has opened up, new forms of aviation have come into picture, where there were a lot of commercial frauds in the era of export incentive, undervaluation, misclassification. So the DRI's scope has enhanced to all these areas, and nobody can undermine the role of DRI. In fact, if you see the annual report of the DRI, the amount of cases they have booked, the amount of evasion they have checked, the duty realized, these are all astronomical figures. So the role of DRI in national security as well as the economic development, nobody can undermine it. But here and there, we also hear some stories about the way the DRI functions, the regard they have for the human rights and all that. There were here and there will be some complaints and all that. But if you have to see the finance secretary in 1957, when DRI was formed, there was a letter from the revenue secretary. There itself, there was a saying that they said, DRI will devise its own procedures according to the needs of the hour, where the ends will justify the means. This is what the finance secretary has said in 1957. The ends will justify the means. How far the ends justify the means, and in the process, if some honest persons are also affected by that, these are all the aberrations. Notwithstanding the importance of DRI, we cannot rule out. So at this point of time, today I'll be dealing with the entire history of the issue. We may have to read some paragraphs of the judgments and all that. So like that, we will proceed. First, if you see Section 3 of the Customs Act, Section 3 of the Customs Act, it creates various designations for the department. It creates various designations for the department. It says there shall be the following classes of officers of customs. It creates various designations, starting from principal chief commissioner up to assistant commissioner, and below that also, Section 3 merely creates various posts. And before proceeding further, I should also confess before you, as I said in the beginning, this particular issue, I have not gone much deep into that earlier. And this Canoned judgment is an eye-opener. And after that, I have made my own research in the last 2-3 days, and I am presenting these particular facts before you. At some point of time, I may be wrong. My interpretation may be wrong. So you are at liberty to point out at the end of the session. So we will be going by that, because I'm not a person who has followed this development. I also belong to the majority of the people who just utter the word Mangali Impex and get an adjournment. Let us confess. But this judgment has given an opportunity to revisit the entire issue. And if there are any flaws in between, if I miss out something, you can always point it out. So Section 4, it talks about appointment of customs officers. Section 3 creates the designation, and Section 4 is appointment of officers. The board may appoint such persons as it thinks fit to be officers of customs. Without prejudice to the provisions of subsection 1, the board may authorize the principal chief commissioner of customs or chief commissioner of customs, or principal commissioner or commissioner, or a joint commissioner or assistant commissioner or a deputy commissioner to appoint officers below the AC. So up to AC, the board will appoint. Below the AC, the board will authorize the other officers. So this deals with the power of appointment of various levels of officers of customs. This is Section 4. Then Section 5, It talks about the powers of the officers of customs, because a basic understanding of all this is required to appreciate the issue better. So powers of the officers of the customs, it says, subject to such conditions and limitations as the board may impose. An officer of customs may exercise the powers and discharge the duties conferred or imposed on him under this act. So wherever certain powers or duties are given on customs officers, such powers can be exercised by the officers subject to the conditions and limitations, if any, imposed by the board. This is the general power of the officers of customs. And there is a subordination. So superior officer can perform the function of the lower level officer also. This is section 5, which gives powers to the officers of customs. Very important sections 3, 4, 5, and another very important section is going to be section 6. We have to read it very carefully. Entrustment of functions of board and customs officers on certain other officers. So what are all the powers that are vested with the board, and what are all the powers that are vested with the customs officers under section 5 that can be given on certain other officers under section 6? It reads as, the central government may, by notification in the official gazette, entrust either conditionally or unconditionally to any officer of the central or state government or a local authority any functions of the board or any officer of customs. So the powers of the board and powers of the customs officer can be given to any other central government department or state government department or any local authority under section 6. So we have to understand this very, very clearly. Now, section 17 is a very important section which talks about the assessment of duty. So it is self-assessment. An importer entering any imported goods or an exporter entering any export goods shall, as otherwise provided in section 85, self-assess the duty. So assessment is a self-assessment. This was introduced long back. And then the law also talks about the word proper officer, which is very important for our discussion today. The proper officer under subsection 2 of 17 may verify the entries made under section 46 or section 50 and the self-assessment of goods referred to in subsection 1. And for this purpose, he can examine, test the import goods or the export goods. So this is a proper officer who can do the function under section 17.2. And 17.4 also talks about the proper officer. And then another important section is section 28. This is the section 28 before 2011 amendment. So under section 28, a show cause notice can be issued wherever any duty has not been levied or short levied or erroneously refunded by the proper officer. So again, we have a proper officer who can issue a show cause notice. And this also prescribes the time limit wherever the import is by a government or educational or research or charitable institution or a hospital. Normal time limit is 1 year. In all other cases, it is 6 months. And whenever there is any fraud or anything, it will be 5 years. So it also prescribes the time within which the show cause notice can be issued by the proper officer. This is subsection 1. And then who is this proper officer? Section 17 uses the word proper officer. Section 28 uses the word proper officer. In various other places also the word proper officer is used. And this term is defined in section 234 as proper officer in relation to any functions to be performed under this act means the officer of customs who is assigned to those functions by the board or by the principal commissioner or by the commissioner. So this is the definition for the word proper officer. So this is the legal framework within which we have to approach this particular issue. Section 3, Section 4, 5, 6, 17, 28 and the definition of proper officer. So these are all very important for our understanding. Now comes the first development on the issue, the first major development on that issue, the decision of the Supreme Court in the case of Syed Ali. That decision was rendered on 18th February 2011. The issue in that case was there was a customs preventive. Apart from the regular commissioner customs who are the regular charge, there was a commissioner of customs who was specifically appointed as a proper officer by a notification for the Bombay port. Whether he can issue a show cause notice, whether he can adjudicate the proceedings. That was the issue before the Supreme Court. It was argued before the Supreme Court that just because he is appointed as a commissioner of customs for Bombay jurisdiction within a territorial jurisdiction over the Mumbai port, under section 4, it does not ipso facto confer the authority on him to exercise statutory powers as proper officer. A customs officer, a customs commissioner preventive who is appointed under section 4 as a customs officer cannot automatically become a proper officer. This is one of the argument. The another argument was learned counsel submitted that the use of the expression proper officer in contradistinction to officer of customs. Two terms are consciously used. The act refers to officer of customs in certain places. It refers to proper officer in certain other places. So definitely there is a difference between proper officer and an officer of customs. If your view is taken that both are the same, then there is no need to define section and the term proper officer. So customs officer is a genus and proper officer is a species of it. All birds are all crows are birds, but not all birds are crows. So all customs officers are not proper officers, but all proper officers are officers of customs. This was the argument put forth. And finally, the Supreme Court has concluded on 18/2/2011. This is what the conclusion. Nothing has been brought on record to show that Collector of Customs Preventive, who had issued the show cause notice, was assigned the functions under section 28 of the Act as proper officer, either by the board or by the Commission of Customs. We are convinced that notification 250 and 251 of 1983 issued by the central government in exercise of powers conferred under section 4(1), appointing Collector of Customs Preventive to be the Collector of Customs for Bombay, Thane and Colaba, did not ipso facto confer jurisdiction on him to exercise the powers entrusted on proper officer under section 28. He can be an officer of customs, but he will not become a proper officer. So that was the decision of the Supreme Court on 18/2/2011 in the case of Syed Ali. This has become as a major shock. So long DRI has been having that all India jurisdiction, notices are being issued, adjudications are being done by them. So all that has become invalid by this particular decision. So definitely government cannot take it lightly. They have to react. So they reacted. Before the government's reaction, we should also understand this decision was on 18/2/2011. In another next 10 days, 28/2/2011, the budget was presented. Finance bill was introduced in the parliament. So within the 10 days, the parliament did not have the time to assimilate the importance of the Syed Ali judgment. Obviously, when the finance bill is presented on 28th, it would have at least been prepared and finalized 10 days before. So they did not have the occasion on 28/2/2011 to take any remedial action. There was an amendment in section 28. Why the finance bill 2011? On 28th February, there was an amendment in the finance bill, but that has not taken into account the decision of the Syed Ali case. If you go to the notes on classes of the finance bill 2011, it says class 41 seeks to substitute a new section for section 28 relating to recovery of duties not levied, etc., so as to make the provisions more coherent and clear. Section 28 is being substituted so as to make the provisions more coherent and clear, as also to harmonize the demand period in normal cases to 1 year. Earlier we saw for government the time period was 1 year, for others it was 6 months. So all these things they wanted to harmonize. That was the purpose of the Finance Bill 2011. Finance Bill 2011 was not with a view to overcome the decision of the Supreme Court in Syed Ali. Obviously, within 10 days, they would not have gone through that at all. So this was the only purpose for the amendment made in the year 2011 budget on 28/2/2011. A new section 28 was introduced. There is no more 6 months time limit, all time limit, either 1 year or 5 years. So like that, they have harmonized it and lot of recasting has been done. A new section 28 has been introduced. There are various subsections. Subsection 4 talks about fraud and all those things, 9 and 8. So what is important is there was an explanation too at the end of section 28. There was an explanation at the end of section 28. We have to read that explanation very carefully. For the removal of doubts, it is hereby declared that any non-levy, short levy, erroneous refund before the date on which the Finance Bill 2011 receives the assent of the President shall continue to be governed by the provisions of section 28 as it stood immediately before the date on which the assent is received. This is very, very important. We have to read it very carefully. So when a new section 28 was replaced, substituted by the finance bill, this explanation has said any notices issued prior to the date of passing of this finance bill, that is 8/4/2011, that will continue to be governed by old section 28, and all new notices issued after 8th April, that will be governed by the new section. That will be governed by the new section 28. So this has been brought in by way of removal of doubts. So we have to note this explanation very, very carefully. When Finance Bill 2011 substituted a new section 28, there was this explanation which said all old cases will be dealt with under old 28, all new cases will be dealt with under new 28. This is very, very important. So this was the explanation. Obviously, this finance bill did not take into account Syed Ali. Then Syed Ali came out. The decision was rendered on 18/2/2011. Slowly its effect was realized, and on 15/4/2011 was the first reaction of the board. There was a circular issued on 15/4/2011. It was a panic. Supreme Court has said the DRI can't do anything. So there was a panic. The panic button was pressed and a circular was issued. They said wherever the investigations are going on and you are supposed to issue the show cause notice, DRI don't issue the show cause notice, send it to the commissioner. They will issue the show cause notice. And wherever you have issued show cause notice by DRI, if the time limit is still available, issue another notice by commissioner. So this was the panic reaction, immediate reaction given by the CBIC. They told that this is an interim gap. We are taking steps how to deal with this particular situation. In the meanwhile, any future notice, let it be issued by the commissioners. And wherever you still have the time limit, wherever you have issued the notice, issue a fresh notice by the commissioner. This was the reaction on 15/4/2011. Another 3 months, 6/7/2011, they issued a notification 44/2011. 44/2011 was issued specifically assigning the function of proper officers under section 17 and 28 to DRI officers. The preamble of the notification we have to read very carefully. In exercise of the powers conferred by subsection 34 of section 2, the Central Board of Excise and Customs hereby assigns the function of the proper officer to the following officers mentioned in column 2 of the table below for the purpose of section 17 and 28. So they specifically sought to rectify the mistake. What the Supreme Court has said, DRI officers are not proper officers. So we are appointing them as proper officers for the purpose of section 17 and 28 under section 234. This is what notification 44/2011. So this was issued. They thought this will take care of the Supreme Court judgment prospectively. Hereafter, there will not be any problem. We are doing whatever is required to be done. This is for prospective. But what has to be done for the past? What are the show cause notices issued? Whatever notices have been issued in the past, how to save that notices? So for that, the government came out with an amendment act. So they brought in an amendment act of 2011. By this particular act, we saw earlier section 28 had 10 subsections. They introduced another subsection at the end, subsection 11. It reads like this: notwithstanding anything to the contrary contained in any judgment, decree, or order of any court, law, tribunal, or other authority, all persons appointed as officers of customs under subsection 1 of section 4 before 6th July 2011. So 6th July, there is a new notification, and any officer appointed as a customs officer under section 4 shall be deemed to have always had the power of assessment under section 17 and shall deem to have been always had been the proper officer for the purposes of this section, that is section 28. So government did two things. For future, they issued a notification 44/2011. For the past, they introduced a section 11 to overcome the decision of the Supreme Court. They said any officer appointed as a customs officer before 6th July 2011, they are valid proper officers for the purpose of section 17 and section 28. So these are the two things which the government did. If you see this statement of objects and reasons for this Amendment Act of 2011, they are specifically referring to Syed Ali judgment. Supreme Court has said so. To overcome that, we propose to add this subsection 11 to section 11. So this will take care of the past cases. So this is the statement of objects and reasons for Finance Bill Amendment Act 2011. This act was also passed somewhere in September 2011. This amendment was passed. Subsection 11 has also come into effect, and government thought that the problem has been solved. Whatever mistake pointed out by Syed Ali has been overcome prospectively by notification 44 of 2011 and retrospectively for the period by subsection 11 of section 28. This is the government's reaction to Syed Ali judgment. And then they issued another circular. They said, they explained all these things. I'm not reading this particular circular and all due to paucity of time. What they said in this circular was, earlier we have given a circular on 15.4. Now we have overcome the problem. Future will be taken care of by 44 of 2011 and past will be taken care of by section 2811. So hereafter you can proceed to do whatever is permitted under law. And the original circular dated 15/4/2011 asking the regular commissioners to issue the show cause notice, that has been withdrawn. So this is the reaction of the government to Syed Ali judgment. Government thought this is enough. We have successfully overcome the Syed Ali judgment. Now, a case came up before the Bombay High Court. Still, it was argued, nothing has been done. Whatever defect has been pointed out by Syed Ali has not been overcome these particular provisions. So still DRI officers are not having the power to adjudicate or to issue the show cause notice. This was the argument before the Bombay High Court. Bombay High Court, in this particular case, that is the Sunil Gupta case, they observed Syed Ali. They also noted the new section which was introduced, and they taken note of the original notification 19/90, by which DRI officers are appointed as customs officers, which is similar to the 17 of 2002. I will come to that later. And 44 is also noted. They said this DRI officers are having the jurisdiction. Whatever challenge has been given, that was not accepted by the Bombay High Court. At that time, in Delhi High Court, the Mangali Impacts matter was pending. On that ground, they wanted the adjournment also. Because the matter is pending in another court, they wanted adjournment here also. The court proceeded with that. And this decision has said, after this Finance Act, Section 28 has been amended, by subsection 11 has been introduced, all those problems have been overcome, and DRI officers are proper officers. This was the decision of the Bombay High Court in Sunil Gupta case. And then this was on 3/11/2014. And after nearly 2 years or 1.5 years, Mangali Impacts came. Mangali Impacts before the Delhi High Court. The issue before the Mangali Impacts Delhi High Court was whether 2811 is sufficient to overcome the defect pointed out by the Supreme Court in Syed Ali. The reason was, earlier we noted one explanation under section 2810. It is an explanation for the entire section. What it said, recall once again, by Finance Bill 2011 budget, a new section 28 was substituted. In that context, an explanation was said, all old cases will be dealt with by old section 28 and new cases will be dealt with by new section 28. New section 28 means sans 2811 because 2811 came subsequently. In September 2011 only section 2811 comes into picture. So this explanation, according to this explanation, old cases have to be dealt with by old section 28. This is Finance Bill 2011 budget. And subsequently when subsection 11 comes, what 11 says, all officers appointed prior to 6th July 2011 are validly having the power to adjudicate under this section. That's what subsection 2811 says. 2811 says, all officers appointed as customs officers prior to 6th July 2011 are proper officers for the purposes of this section. But this explanation runs counter to that. This explanation says all old cases have to be dealt with under only old section 28. Old section 28 did not have subsection 11. And subsection 11 says all officers appointed before 6th July are valid proper officers. So there is a conflict between this explanation 2 and subsection 11. The court said we cannot ignore that. We cannot just like that ignore this particular explanation. It may be a conscious decision of the government also, but anyway, it cannot operate simultaneously. Once the explanation says that all old cases have to be dealt with under old section 28, we have to go by old section 28. Old section 28 suffers from the lacuna as pointed out in Syed Ali. So still, even after introduction of subsection 11, Syed Ali has not been effectively overcome. So Mangoli Impact said, we cannot reconcile the contradistinction between this explanation 2 and subsection 11. Still, the lacunae prevails. Still, the lacunae prevails. These are some important paragraphs in the judgment, which I am just skipping. I'm not reading. Paragraph 52, 62, 66. And finally, this is the conclusion worth reading. As regards the period subsequent to April 2011, it is evident that if the administrative chaos, so that is another issue. The Supreme Court has also said you cannot give a wider jurisdiction to so many officers. It will create chaos. One officer will decide something, another officer will again start issuing the show cause notices. There will be complete anarchy. You have to clearly demarcate the jurisdictions. So that is what the Supreme Court has said in Syed Ali. That is also another point in the Syed Ali case. In para 70.3, the Delhi High Court said, as regards the period subsequent to 8th April 2011, it is evident if the administrative chaos as envisaged by the Supreme Court in Syed Ali should not come about, there cannot be any duplicating and overlapping of the jurisdiction of the officers. It would have to be ensured through proper coordination and administrative instructions issued by CBEC that once SCN is issued specifying the adjudicating officer to whom it is answerable, then adjudication officer subject to such officer being a proper officer to whom function as assessment has been assigned in terms of section 234 will alone proceed to adjudicate. So it has given some instructions to the board how the matter has to be administratively dealt with. So this Mangali Impacts has said whatever has been said to overcome, whatever has been done to overcome Syed Ali, still that is not sufficient because of the conflicting points that are emerging from explanation 2 on the one hand and subsection 11 on the other hand. Explanation 2 still says it has not been removed. It says all old notices have to be dealt with only under old 128. Old 28 suffers the vice as pointed out by the Supreme Court. So I can't do anything. For new, okay, you are giving the jurisdiction to DRI officers. That may be valid, but you have to give proper demarcation. It should not lead to any administrative anarchy. So the CBEC has to do the necessary thing. This was the decision in the case of Mangali Impacts. And this was the decision, and still again appeal has been filed and appeal is still pending in the Supreme Court. And now comes the Canoned decision. Now comes the Canoned decision. It says Section 28 says it uses the word proper officer. It means there are various words in the Act. Customs officer is used, officer of customs, the proper officer. So Section 28 uses the word the proper officer, and the adjective the specifically refers to a particular person. It is not a proper officer or any proper officer. It should be the proper officer, which means an officer who assessed the duty or his successor. He alone can issue the notice. Whoever has assessed at the first instance, the same proper officer, he may not be there, he might have retired. In that case, his successor. They alone can do that, and a DRI cannot exercise the function of the proper officer. This is one of the findings of the Supreme Court. It says 17.2, there is a notification 17.2, which superseded 1990, which we saw about 1990 earlier. So it superseded by 17 of 2002, under which DRI officers are appointed as customs officers. Under Section 4, DRI officers are appointed as customs officers, but that is not sufficient. They should also be made proper officers. It is not only sufficient that they should be appointed as customs officers, they should be made as proper officers for the purpose of Section 28. Then the government produced notification 40/2012. 40/2012 reads like that. In exercise of powers conferred by subsection 34 of Section 2, the CBEC hereby assigns the officers and above the rank of officers mentioned in column 2, etc., etc. The functions of the proper officer in relation to various sections of the Customs Act given in the corresponding entry in column 3. So specifically, section 28 function has been assigned to a deputy commissioner. There is a regular deputy commissioner, not DRI deputy director, a regular deputy commissioner has been specifically given the power. His power can be exercised by his superior, which is the commissioner, and ADG DRI is equivalent to commissioner, and that is how DRI officers can become proper officers. This is one of the argument put forth before the Supreme Court. And there is also another notification. I'll come to, 44 of 2011. 44 of 2011 specifically appoints DRI officers for the purpose of section 17 and 28 under section 234. In exercise of the powers conferred under section 234, DRI officers are specifically appointed as proper officers under section 17 and under section 28. But what the Supreme Court has said is, you are assigning the function of section 28 to DRI officers in purported exercise of your powers under section 234. Is it a section giving you the power to do so? No, it is a definition section. 234 is the definition class which says proper officer in relation to any functions to be performed under this act means officer of customs who is assigned to those functions. So assigning is elsewhere. You cannot issue the notification under section 234. 234 is not a section which empowers the board and gives the power to the board to issue a notification prescribing a proper officer. It only defines who is a proper officer, and Supreme Court traces section 6. Section 6 is the section which deals with giving the power to give entrusting the functions on customs officers. All people are appointed as customs officers. DRI officers are appointed as customs officers. But if you have to make them as proper officers, you have to do it under section 6 and not through section 234, because 234 is only a definition section and the power is traceable to section 6. This is what the Supreme Court says. With my limited understanding of this particular judgment, I have certain reservations with due respect to the Honorable Court and Honorable Parties and Councils. As I said in the beginning, in my disclaimer, my acquaintance with this particular issue is hardly 3-4 days old. So I may commit some mistakes. I may do some misinterpretations also. It is for the august audience to correct me if at all I am correcting. So with my limited exposure to this particular subject, in my humble view, what I feel, there is much more to this particular issue. There is much more to this particular issue which has to be gone into academically during this particular session. With due respect to all the parties and all the courts involved, we have to do a further probing in an unbiased manner. So, 40/2012, the Supreme Court has said it is not valid because you are issuing it under section 234 and not under section 6. Is that a correct approach? What is section 6? We have seen it in the beginning. Section 6 deals with entrusting the functions of the customs officer to any other central government officer. But DRI officers are already customs officers. They are appointed under section 4. So we will read section 6 once again. The central government may, by notification in the official gazette, entrust either conditionally or unconditionally to any officer of the central government or state government or local authority, any functions of the board or any officer of custom. So the powers which are already given to the customs officer can be transferred to any other central government officer or state government officer under section 6. There are so many notifications issued under 6, giving the powers of customs officers to police officers, to Tahsildars. In the state of Kerala, police officers have been given the powers of customs officers. In certain Lakshadweep, the Tahsildars are given the powers of the customs officers. But in my humble view, section 6 may not be required to give powers to those officers who are already customs officers. So section 6 deals with a situation where the powers of the customs officer can be given to any other person who is not a customs officer, because what is sought to be given, what is sought to be transferred is the powers of the board and powers of the customs officer. So customs officer's power need not be given to another customs officer. That the government can do anything. But if the customs officer's power is to be given to any person who is not a customs officer, then we have to fall back on section 6 and issue a notification. But DRI officers are already customs officers appointed under section 4 through notification 17 part 2. This one particular aspect, whether the Supreme Court addresses this particular issue, I feel that this has not been addressed, or what is the answer to that? Maybe the other participants also, they can share their views on this particular issue. This is one point which I would like to highlight. Then, how will a customs officer become a proper officer if section 6 is not applicable? With due respect to the Honorable Supreme Court's observation, if section 6 is not the section to appoint a proper officer, nowhere in the Customs Act there is a specific power available. There is only a definition of section under section 234 who is a proper officer. How to appoint a proper officer? I am not able to find any provision. Section 6 is one answer which the Supreme Court says. And apart from that, I do not find anywhere how a customs officer will become a proper officer. I am not able to point out. Second, another important doubt which is arising in our minds is about the Supreme Court says whoever has assessed the tax, he is the proper officer to reopen it by way of issue of show cause notice. But we are under the self-assessment era. The officer's assessment are only in some selective cases. Whenever the officer opens for examination and passes an assessment order, then he is the proper officer who can reopen it. But when the assessment is by way of a self-assessment, how this judgment will have its impact is another area. So once the assessment is by the assessee, how this ratio of this judgment can become applicable? Who will be the proper officer? Because the assessment is by the assessee, not by the proper officer. And the proper officer has to reopen it. So how this judgment will be relevant in cases of self-assessment is another area which we have to deal with. And another, Supreme Court has said 40/2012 is not valid because it should have been issued under 6 and not under section 234. Because 234 is only a definition section and the source of power lies in section 6. If that is the case, 40/2012 is the omnibus notification where all officers are appointed. The commissioner, the deputy commissioner of customs, all regular officers of customs are given the powers under various sections, including section 28. They are appointed as proper officers only by that notification. If that notification is not valid, as held by the Supreme Court, because it is not issued under section 6, but under section 234, the consequence will be even the regular customs officers cannot issue any show cause notice today. Even the regular jurisdictional customs officers are not proper officers for the purpose of section 28 because they are appointed under section 234 and not under 6. So this will be another serious consequence of this particular judgment. Nobody in the customs department will be, I may be wrong, I may be missing something also. And these are all the issues which I am just throwing open for debate during this particular. So these are all the various facets of the Supreme Court decision, and these are all the points which we have to be debated. And in my view, as I have already put forth, section 6 may not be the relevant section to appoint the proper officers, because once they are appointed as the customs officers, the source of power to appoint the proper officer is nowhere available except under section 234. And section 6 is applicable only to give the powers of the customs officer to non-customs officer, other central government officers or local authority, etc. So these are all, so it will now be clear, it is not the end of the road for either for the assessees or for the department. There are various avenues which are still open in future, which we have to be discussing in various forums. So with this initial explanation and debate, I am now just opening the floor for the debate. And before that, I request one of our distinguished chief guest, Mr. B.V. Kumar, who is a veteran in DRI, I can call it, and he has to his credit, lot of investigations he has done. He has worked in NCB, he has worked in DRI, And it is amazing to see he retired in 1992. At the time, 1992, I have not even joined the department. I was just 22 years old and working in AG's office. And he retired in 1992. And after 28 years of retirement, he is now before us, and we are very honored to have him. So first, I request his views on this particular subject and the decision of the Supreme Court for a few minutes, sir. Yes, Mr. Kumar, sir. You can unmute yourself, or the host can unmute Mr. P.V. Kumar. Host.
Thank you, Mr. Natarajan. It was an education for me to hear your erudite presentation of the whole issue. And you are a veteran actually in the knowledge of the whole subject. And it was actually a fresher course for me when I heard you today, taking right from the beginning, almost starting from the first Syed Ali's case, which started in Bombay, when the Commissioner of Customs came to issue the first show cause notice, and then its legality was questioned and subsequently tendered in the Supreme Court, as pointed out by you. Now, the board as well as the DRI formations in different parts of the country, from the feedback which I was getting through one of our additional directors who retired some time back, each time they were asking, what are the notifications? Where are the notifications? Then, searching my old books, I found one notification which was issued in 1963. It was a notification number 37 dated 1st February 1963, empowering all the officers of the Directorate of Revenue Intelligence, except Hindi officer, administrative officer, clerical staff, class 4 staff, to exercise the powers specified in sections 100, 101, 103, 104, 106, 107, and 110 of the Customs Act 1962. Subsequently, again, I somehow had all the old manuals, and I checked up in one of the old manuals that one notification was issued under section 4, again appointing DRI officers, again with similar functions. And nowhere they mentioned either section 28 or section 2, bracket 34, subclause 34, or section 6 or section 28, or any of the sections cited by you in your wonderful presentation. So there, very, very few sections were quoted, like in this particular notification which I quoted, which has been subsequently amended from what I found in section, the notification issued again under section 4. Where it was issued in, this notification was issued in 2004, 30th of June 2004. And there they again said appointment of DGRI, DGI commissioners, additional commissioners, and deputy commissioners of customs as customs officers. Then they said in exercise of the powers also under section 4 of the Customs Act, and in supersection of the notification of the Government of India and the Ministry of Finance, Department of Revenue, number 30 of 97, Customs NT dated 7th July 97, the Central Board of Excise and Customs hereby appoints the officers specified below to be the Chief Commissioners of Customs, who shall have jurisdiction over the whole of India, Director General of Revenue Intelligence, New Delhi, Director General of Inspection, Customs and Excise, the Commissioner of Central Excise to be Commissioners of Customs, and then the Commissioner of Central Excise Appeals, the Additional Commissioner of Central Excise, Deputy Commissioners of Central Excise, etc. Again, they are not given the same powers to the Deputy Directors or Additional Directors of the DRI in this. Then there was some as pointed out by Ms. Natarajan, various other officers of the other departments, powers were granted under section 6, where even the Forest Department officers, the Coast Guard, then the Superintendents of Police or Deputy Superintendent of Police posted on the coast, all of them have been given powers under section 6. The mute point that has been raised by Ms. Natarajan is whether the section 6 as it stands today, does it give the power to entrust the powers of a proper officer to the officers of the DRI? And according to him, probably section 6 is still not the appropriate section. If that is not the section, I wonder probably there's a deficiency in law. Because in section 6, if you see, the entrustment of functions of board and customs officers on certain other officers. The central government may, by notification in the official gazette, entrust either conditionally or unconditionally to any officer of the central or state government or a local authority any functions of the board or any officers of customs. Now, officers of the central government, definitely our customs officers or the DRI officers, they are all officers of the central government. Now, if you see one particular notification issued under Section 6, I'll just for a specimen, I'll read out. Now, the notification says, which relates to the DRI, specified officers of the DRI entrusted with the powers to search premises. In excess of the powers conferred by Section 6 of the Customs Act 1962, the central government hereby entrusts the joint directors, assistant directors, or deputy directors, and the assistant commissioners working in the Directorate of Revenue Intelligence, New Delhi, to the function of an assistant commissioner of customs or deputy commissioner of customs under subsection 1 of section 105 of the Customs Act 1962. So only under 105 it has been granted, but then the notification shows that the powers which can be exercised by an assistant commissioner or a deputy commissioner of customs can be exercised by the officers of the DRI. Once he can exercise the powers of the assistant commissioner of customs or the deputy commissioner of customs, automatically he becomes a proper officer under Section 28. I mean, that's my view as it stands today, but no notification has been issued till today under Section 6. At least if they had done that after it was pointed out even earlier, the deficiency that was pointed out in Mangalian Pek's case or in Syed Ali's case as decided by the Supreme Court, probably it would not have come to this pass. And still, we are not sure whether the government will completely remedy the situation even through this budget. So I think a lot of parleys are going on, but I think the powers that be are busy with the elections and other activity that goes on with the elections, rather than concentrate on this serious issue, because thousands of crores of revenue, apart from contraband, are held up in adjudication proceedings and also in appeal proceedings. Subsequently, I'm sure Mr. Natarajan will be aware, after the Mangalian Pek's case, there are two decisions of the Delhi High Court where they have said the matter should now be sent back to the tribunal, where the tribunal will decide the jurisdiction, whether the DRI has the power to issue a show cause notice or not, and then decide the merits of the case. And then there are these two judgments, they just copied each other. Then came the Punjab and Haryana High Court decision where they said, no, that's not correct. The correct thing should be, it should be kept by the tribunal, and tribunal should not decide and await for the final decision of the Supreme Court in the appeal filed by the department against the Mangalian Pek's case. So there is even understanding. Now, I can't understand the Delhi High Court decision subsequently, which was given after the Mangalian Pek's case, where a tribunal, which is a subordinate appellate authority, can decide, yeah. So, shall I proceed, Mr. Natarajan? So, I can't understand the Delhi High Court decision given subsequent to the Mangalian Pek's case, how a tribunal, which is a subordinate appellate authority, can decide the wires of the decision of the Delhi High Court. I mean, this is something which I can't understand how the honorable judges of the Delhi High Court gave such directions. So I personally feel, as it stands today, the Punjab and Haryana High Court decision was correct. They said the tribunal should keep the cases with themselves, await for the Supreme Court decision on the appeal filed by the department in the Mangalian Pek's case. But as far as the powers entrusted under Section 6 of the Customs Act is concerned, I personally feel, I don't know how the Ministry of Finance in the Department of Revenue and the CBIC, they have lost sight of this, and they should issue notifications under Section 6, empowering the DRI officers as the proper officers or enter specific functions under different sections of the Customs Act. It is very surprising, only in the Customs Act we see this provision of the proper officer. In other acts, it will say any customs officer or any excise officer or any officer working to enforce the functions of a particular enactment. That's the type of language that's normally used. The concept of the proper officer, unfortunately, was introduced by Mr. M.G. Abrol, who was the person who claims to have drafted this particular enactment, which stood the test of time, but for this unfortunate word, the proper officer, which has created so much of problems, particularly for investigating agencies, the DRI, the DGCEI, and the officers of the Customs Preventive Commissionerate. So that is a real major issue. And what I understand is, again, probably they're trying to do a firefighting job by introducing some amendment through the finance bill, because it has not yet received the assent of the president. So probably through a backdoor method, they'll introduce an amendment in the finance bill, and they will try to push through. I only hope sufficient application of mind will be exercised by consulting the Ministry of Law, the senior law officers, namely the Attorney General and the Solicitor General of India, before they take a final decision. But I beg to differ with otherwise the wonderful presentation made by Mr. Natarajan, which was personally an education for me to understand the whole concept of the different provisions of the Customs Act. And but except for that small difference with him, I totally agree with the wonderful presentation. Thank you, Mr. Natarajan.
Thank you, sir. Thank you very much for taking trouble and attending our session. We are really very honored. So may I request our Mr. N. Venkatraman, ASG, has also joined today's session, and very special thanks to him. He has also thought it fit to join us despite his busy schedule. So may we have your views, sir? May not be the government's view at this point of time. May we have your personal views, sir?
Thank you, Natarajan, and Namaste, B. Kumar, sir. It was such a pleasure.
So maybe you can open your video, sir.
No, I can't open the video at the moment.
Okay.
Please pardon me for that.
Okay.
It was a enlightening session for both of us, for all of us, through both of you. And Namaste, sir, to B. Kumar. It was very scholarly, though short. It's big learning. Nataraj, I have only one request. Can you share again one last time Section 6 and Section 234 before I try to comment on this?
The slides.
Section 6, yeah, it's there. Oh yeah, we'll stick to proper officer first. Yeah. The central government may by notification in the official gazette entrusts either conditionally or unconditionally to any officer of the central or state government or local authority any functions of the board or any officer of the customs under this act. See, the source of power here, as seen chronologically by the 3 notifications issued by placed by you, and of course the 2 notifications issued as referred by Kumar sir. It made the expression used is any officer of the central or state government or local authority. But central will include customs is one possible view, no doubt about it. But we can say that it need not include, going by the arrangement of the entire enactment, this is nothing but an outsourcing section. Because the starting word is entrustment. Whereas a custom officer is by its natural choice of appointment, he inherits that office and he executes that functions as programmed under the act. Whereas an entrustment is something which you don't claim it naturally and you claim it otherwise through a source. So this is only a source of power traceable to the central government to outsource whenever required to central, state, and local body. And you read, see, state government officers do not naturally fit into the scheme of customs officers. Local authority do not fit into the scheme of customs officers. And even applying the principle called doctrine of nauseter associate, central here should be read in an abridged manner, not to include customs, read with the expression interest fund. This is therefore possibly even some notifications had been issued under section 6. It may be only a surplusage, need not necessarily be a source of power. Is my immediate, you said you are 3 days or 4 days old, I'm only 1 hour old in this matter. In fact, this matter came to me for doing it, but because I had given opinion on the classification for the company who are importers, who are before the court, I had to decline it. But at that point of time, we never knew that 28 was an issue. They all said it was only a classification issue. Had 28 been an issue, I have myself given an opinion prior to taking this assignment that it may not stand, and could have argued this piece alone because it has an overarching impact. But I never, that visibility we did not have. It possibly developed in the course of the argument, never mind. But government has decided to consult us, and we will be getting an opportunity to examine what. So, but at this moment, this is not a government view. I have to put the caveat, it's my personal view, listening to you for 1 hour. So section 6 may not necessarily include customs officers for 3 reasons narrated above. Now, can you go to 234, please?
Yes, sir. Yes, sir.
Yes. Yeah. Proper officer in relation to any functions to be performed under the Act, to be performed, is it's a continuous activity. It is not so we can't take only the expression assigned and deal with it, to be performed. So it is performed in future too. Means the officer who is assigned. So performance based on assignment. To say that assignment has to be elsewhere and performance is conceived here looks to be a slight disconnect at the moment. We have to explore and do a better research. But my first immediate, when you showed the slide in the first instance, this was so. And thirdly, most important, today it is not just a DRI. If this law has to hold, which means all show cause notices. Now to contend saying that section 28 uses the expression the proper officer, and therefore it is not proper officer vis-a-vis the proper officer. The proper officer is one who assigns, and therefore, see, it looks to be slightly narrow for the reason the expression the is to signify the functions performed, not signify the person who is performing the function. One who performs the function under 28 becomes the proper officer. To say that D means A and not the functions performed by those who occupy the position A looks to be, again, an issue which possibly needs to be deliberated. So going by 234, going by the history of 28, which nobody will know. If you go to section 6, as Kumar sir also said, tracing to 63 notification, as of now, nobody is assigned as a proper officer to do assessment. Therefore, nobody is a proper officer. So why is DRI show cause notices? All show cause notices should fall flat based on the Supreme. So tomorrow, in fact, we can easily migrate to GST tribunal if you want. In one sentence, all matters tomorrow, all tribunals can dispose. In which a one-line order based on the Supreme is far-reaching. So more than an amendment, I think this matter needs to be re-argued if required at an appropriate juncture. Whatever is the option, government will consider this. So these are the immediate 3 views that occur to me in this understanding of 1 hour. And I would once again thank you for this very, very enlightening sequence of talks. And also so nice to see Kumar sir after a very, very long time. Thank you so much. These are the immediate things.
AG sir, may I say this, sir? You may also see section 4.
Yes, that's why it's sparking
appointment of officers of customs.
Sir, can you enlighten on section 4, sir?
Can you please share section 4 on the screen, Nuts?
I'll do that.
Section 4 is 1 line, sir. The board may appoint such person as it thinks fit to be officers of customs.
And therefore, so that is again an exclusion to section 6 then, entrustment. Yes. Because an appointment happens under 4, you don't have, and therefore, and the last point, the 4th point possibly occurs to my mind is, see, it is not a case of a conflict between a rule and a section, or a notification under section, or a schedule under section. See, this ragbag legislation in a parliamentary legislation, Supreme Court has said, You can tax income tax under the Customs Act because source of power is there. Once there is a field available, then the field can be exercised in any manner you want. Only choice is, do you have a source? Now, to say that a crossfire between 234 and Section 6, both are only parliamentary sections, both are only in status sections. And to say you should notify there and not notify here looks to be extremely technical. And Section 4 may also then come to your aid. Once you appoint, yeah. These are my views at the point. Subject to correction, subject to government's final view. These are personal views at this point. I want to put
I
that clear.
think there are some notifications issued under Section 4 also, sir. So that's why we are very confident DRI is the proper authority. I think in this line of argument only we are taking in the Mangali Influx batch, sir.
And Mangali, in fact, I have a doubt about the correctness of Mangali. See, they are talking about the First Amendment and the Second Amendment 2811 as a later. The First Amendment was a removal of, see, contemporaneous exposition, even though it's available for ancient statutes, it is now referred to even in the present modern statutes. So if you see the contemporaneous understanding of the government, there was a knee-jerk amendment first, and then there was a clean amendment subsequently. So when you read the statement of objectives, 2811 subsumes the earlier mechanism. And therefore, to say that it is conflicting and therefore, the Supreme Court has not gone on Mangali, but Mangali on a standalone basis also looks to be, may not be right, is the view at the point.
Thank you, sir.
A second, Ms. Natarajan.
Thank you.
I just a very short point. Taking into account the remarks of learned colleague, Mr. Who just now spoke, Mr. former AD, DRI. What I have to say is Section 2, subclause 34 is a section giving definition of who is a proper officer and what are the functions that board may interest in. It's not a source of power to entrust functions. It's a definition. So you cannot treat Section 2, subclause 34 as a source of power to entrust functions to any officer, either of customs or some other department like the DRI or the DGCAI. That is my first submission. Then you have to search for a source. The search for a source is already under Section 4. Officers of the DRI have been entrusted with the functions of a customs officer. Again, they did the mistake of not granting specific powers under specific sections, whether they are proper customs officers under different sections. That also was not properly done. That's also the first correction that is required to be made. The second correction definitely is subject to Ms. Natarajan agreeing with me or differing as he already has put his caveat, is that under Section 6 again, once again they have to declare that DRI officers, starting from the DG down up to the investigating officer and the intelligence officer, should be declared as proper officers under specific sections, which is necessary. Unfortunately, the law, every section they say the proper officers and other things. So if that is not done, at least in the short term, till the whole thing is reviewed and probably rectified, it is necessary to do that in the short term. I only hope the government will do that. Otherwise, the impasse will continue for some time to the advantage of the SSCs as well as the smugglers.
Thank you, sir.
Just one observation, if you permit me. I think, as Mr. Venkatraman has pointed out, I think Section 6 application has absolutely seems to be ruled out. Having given the power to appoint officers of customs under Section 4 to the CBEC, there is no question of central government issuing an official notification for that. So that central government in Section 6 has to be read as other than the officer of customs, as correctly pointed out. And as Mr. Kumar now pointing out, while Section 234 may not confer definitely power to appoint, but you can easily see Section 4 is what is talking about officers of customs. Officer of customs is what we call as a bigger set. And out of the bigger set, a smaller set is a proper officer. It can be equal to the bigger set also or not. That is something which we are, that is whether it creates chaos, etc. We'll have to see separately. But the way proper officer is termed is proper officer is a subset of the officers of customs. Therefore, when Section 234 talks about proper officer of customs means those officers who have been entrusted the power, specific power and functions. What we will do is under section 4, out of all the officers of customs notified, you may notify these are the officers of proper officers for these purposes. Therefore, the source of power, in my humble opinion, again, a lot more experienced people are sitting, should be traceable to section 4. Read with section 234, you may be able to notify who will be the proper officer of customs. But just because section 234 has been notified, I don't think whether a notification could come so bad. That again is something which probably the senior officers will look into it. But section 4, read with section 234, will enable the government or the CBEC to allocate out of the various officers of customs, those officers who will have section 17, those who will have 28, those who will have others, different. Of course, one other thing is to give everything, but if you give everything, we have the same problem, whether the underlying problem of Syed Ali has been removed. It's not an amendment. Amendment also remove the underlying, the erroneousness which is chaos resulting from too many officers being entrusted with the same set of functions. So to address that, if you are giving a specific set of officers the power of the proper officer, let's say in section 17 or 28, it may, I think, be valid. The other, of course, again, we are having a lot of problems in the past, but in future, apart from the amendment, one of the things is, if the notice is issued by a deputy commissioner of a commissioner, even where it is investigated by DRI, etc., it would still not probably give a problem. But we still have to address this issue of officer of customs or a proper officer of customs. Where do you derive that power? Certainly, it looks to me like section 4 with 234 and not under section 6. So that seems to be a clear position. That again, a personal view from my side. Yeah, thank you.
Thank you, sir. So another person.
One small point which our Mr. Partha just now spoke. Here, one of the basic things while interpreting law is there should be harmonious construction and harmonious interpretation so that there's no conflict between the one section and the other section. And as pointed out by Mr. Parthasarathy, what to keep in mind is section 4 appears to be a larger section, larger in terms of scope of entrusting functions. So under section 4, please entrust, if the legislature, probably it's only a suggestion, which I hope people in the board and the Department of Revenue will take note of. Under section 4, notify the officers of the DRI or DGCI or whatever it is, and entrust them with different tasks. You declare them as officers of customs, and we may not say proper officers, at least define them as proper officers of customs under different sections. Then go to section 6. And then under section also you say, under section 28.4 or whatever sections you want to say, or for powers of adjudication, for issue of show cause notice, again enters the functions under 6. But there should not be any conflict between 4 and 6. 4 should be give general power to the officers of DRI and the DGCI, and then specific functions should be given under section 6, because section with the functions, they start with what the functions interested. That's my personal view. I hope this type of harmonious construction will be done by the board in the short run now to overcome the legal difficulties. And we have to also remember that they were thinking of review. I don't think it's that easy, because this is a larger bench decision of 3 judges. So it has to go before the judges, at least 5 judges of the Supreme Court. A constitutional bench has to be constituted by the Chief Justice of India before this can be revised. Probably a review can be done by the same bench, and normally in a review, since the same bench sits, they will not set aside their own order unless some loophole is pointed out, or probably it may be pointed out that other sections of the Customs Act were not discussed in this particular decision, as pointed out by Mr. Natarajan. Thank you.
Thank you, sir. May I now request Mr. Krishnanand, to whom also this particular issue is very close to his heart, and he has been dealing with this issue for quite long. So, Krishnanand, can you just join and share your views?
Thank you for the opportunity. In fact, this issue came up for consideration before one of the honorable members of the tribunal, who at least on my screen is sitting next to me, Mr. P.G. Chako. I argued this matter before him when he was sitting in Bangalore with respect to the Syed Ali case. And to be honest, I have argued it before a number of forums, including the High Court of Madras, and none of them accepted the argument when the amendment to section 28, particularly insertion of 2811, came into force. But Mr. Chaka was the first one to accept that That amendment does not appear to be proper, and he gave me relief in that matter even before the Mangli Impex case. So I'm grateful to you, sir, to have understood my point of view at that point of time. Now, what today's discussion has actually left out is the judgment of the Supreme Court of the case of Syed Ali and Mangli Impex, to the effect that two officers cannot have concurrent jurisdiction in the very same place. An officer of DRI and a customs officer who's doing an assessment cannot be vested with the same power. Now, actually what happens is that there are transfers taking place in the customs department as far as assessment of bills of entry go. The Supreme Court on both the Supreme Court of the case of Syed Ali very categorically said an officer who has the power of assessment and reassessment alone can exercise the jurisdiction under Section 28 and not any other person. Now that has been reiterated by the Honorable Supreme Court in the case of Canoned by stating the very same thing, saying that only the person who is empowered to assess a bill of entry or reassess a bill of entry or his successor alone can exercise the power under the said section and not any other person. Now, for example, in the customs department or in the excise department, all of them are officers of customs and officers of central excise. That does not mean anybody can do anything in the department. Therefore, the department has devised methods and ways to allocate certain jobs and certain work which can be done only by one person. Otherwise, it will be utter chaos. That is why functions are imposed upon certain persons and only that person can exercise the function. Take the case of Syed Ali itself. There are two commissioners. Both are commissioners appointed under the provisions of the Customs Act. Supreme Court said the commissioner who had the power of assessment alone has the power to issue demand under Section 28. The commissioner preventive does not have the power. If such is the status of a commissioner of customs, imagine what about the officers below the rank of a commissioner, which means any officer will undertake any work under the jurisdiction of the commissioner. That cannot be a position at all. So I find such an argument to be fatal to the entire proceedings and the provisions of the Act. Now, as pointed out by Mr. B.V. Kumar, who incidentally had also been the head of the DRI in his heydays, knows pretty well that the DRI's job is only to investigate. They can investigate, submit their investigative report to the concerned jurisdictional commissionerate. That is why you have the word jurisdictional commissionerate. Jurisdictional commissionerate, which commissioner or deputy commissioner or a person of the rank above the rank of a deputy commissioner will issue the show cause notice. As already pointed out by Mr. Natarajan in the beginning, there came a stage after the Syed Ali judgment when all the show cause notices issued by the DRI were withdrawn and the show cause notices which still had life were reissued by the Commissioner of Customs. Now, suddenly from nowhere, after Section 2811 was inserted by a Validation and Amendment Act, the DRI suddenly presumed that they have got back all the powers which was taken away from them and started issuing show cause notices on their own again. That is the blame that they have to take upon themselves, which has resulted in the present judgment of the Supreme Court in the case of Canoned. So, to such an extent, you cannot entrust powers on every officer of customs by whatever name they be called, except the proper officer, where the Supreme Court in the Canoned judgment has made a clear distinction between a proper officer and the proper officer. The Supreme Court in this Canoned judgment categorically says the proper officer for the purpose of Section 28 means the officer who has the power to assess and reassess or his successor. He alone is the person who can demand duty. So to that extent, I think there is no lacuna in the judgment of the Supreme Court. Of course, Mr. Venkatraman is now entitled to disagree. Earlier, he was obviously on my side. Now he is on the other side. So he is entitled to disagree. And Mr. B.V. Kumar always, now that he has retired and come into practice, will certainly agree with my view, which he again tried to point out that, these are certain lacunae. If you see the notifications referred to by Mr. Kumar, right from 1963 till date, in respect of the officers of DRI being termed as proper officer or officers of customs, specific sections of the Customs Act alone have been demarcated for them to exercise, not the Customs Act.
Only search, seizure and investigation.
Yes. So therefore, when the powers under Section 28 have not been conferred upon the officers of DRI, where is the question of the DRI exercising powers under the said section? Because the notification specifically cites X, Y, Z sections, not all sections. 1, 2, 3, 4, 5 sections alone can be exercised by the officers of DRI. So therefore, the proper officer, the word the within the apostrophes, the proper officer has a lot of meaning, and the judgment of the Supreme Court is very categorical and clear to that effect. And therefore, the show cause notices issued by the DRI invoking the provisions of Section 28 are unsustainable as held by the Honorable Supreme Court. Now, what will happen in future? It is for the government to decide. As Mr. Kumar pointed out, of course, election season is there, and I personally and particularly feel there is a lack of legal acumen in the TRU to draft legislation. The legislation inserting Section 28, subsection 11 itself was very badly worded. And they forgot to remove the explanation under Section 2811, which caused all the confusion. Even today, for your knowledge, the said explanation still exists. So if the said explanation still exists, how will you interpret a provision and interpret a particular section? The Delhi High Court categorically says you have to read the entire section. You cannot leave the explanation and decide only the Validity and Amendment Act. You have to read it along with the explanation. And reading along with the explanation means you go back to the old Section 28, where DRI had no power. Secondly, as far as Section 2811 was concerned, you may please note they use a particular word for the purposes of Section 17 and this section. If you read the words this section came into effect on 8/4/2011. New Section 28 came into effect on 8/4/2011. The amendment was inserted much later, after a period of about 8-9 months. Now, the earlier Section 28 prior to 8/4/2011 had only 3 subsections, whereas the present Section 28 now has 12 subsections. I'm talking about the period 11 subsections when subsection 11 was inserted. So the purpose of this section means even the Validation and Amendment Act came into force only with effect from 8/4/2011, when Finance Act 2011 got the presidential assent. Therefore, the department assumed that by bringing the Validation Act, they had given life to all the show cause notices issued before 8/4/2011, which is a misnomer and misunderstanding of the provision. Because this section is very specifically used in the Act itself. It is not even in the explanation. So therefore, the powers of the DRI officers presumably came into force only from 8/4/2011. Now that again has been distinguished by the Supreme Court by distinguishing the words a proper officer and the proper officer. So as an SSC's counsel, I obviously would say the Supreme Court judgment is good judgment and precisely on the point, and obviously in favor of the SSCs. But as Mr. Kumar pointed out, notwithstanding that he is now an SSC's counsel and not the department's counsel, he still fears for the benefits that will accrue to the SSCs and smugglers. In fact, any activity of confiscation or anything under the Customs Act is called smuggling. So anything under the Customs Act is smuggling. So be that as it may, as long as the judgment stands and as long as the department is not in a position to do anything, whether the review is accepted or amendment in law is brought in, the judgment, the larger bench judgment of the Supreme Court of the case of Canada is here to stay to the benefit of the SSCs. Thank you.
I
One
agree
small
with
comment I
Dr.
wanted to-
Krishnanand.
Yes, sir.
To the extent that from Syed Ali to this particular case, going about the proper officer and trying to say that as a result he cannot, I think that portion has come out clear. The earlier discussion was more with reference to whether you derive the power from Section 6, etc. Dehorse that, I think, as I said, the fundamentals of Syed Ali, that if you assign the same function to too many officers, there will be chaos, that has still not been removed. Apart from, of course, the pointing out Section 2811 and the explanation remaining and pointing out this section, those problems are all what are being addressed actually in Mangali Impex, notwithstanding the amendment, retrospective amendment, it still does not validate all those old show cause notices. This is what the argument in Mangali Impex is still to be addressed by the Supreme Court. But what has been clearly said is the proper officer means has a very, very specific meaning, and DRI can never become that they have been notified under 234 or Section 6 not applicable with there. Irrespective of how they are notified, they cannot be a proper officer. That seems to have very, very clearly come out. That ratio seems to have come out clearly, and as he rightly said, seems to be in favor of the SSC for the time being. And also, because Kumar pointed out what function you started off with and what function now you are going, I think those are totally different things. I will leave it to the larger judgment of the government on that.
Thank you.
On a personal note, which one personal note on what Mr. SK pointed out about me, as long as I was in charge of the DRI, I was extremely fair to ensure that when there was no evidence of any what you call an act of commission or omission on the part of an assessee, we always dropped it suo motu. We never took up a case where, and we used to do investigation or gathering intelligence almost for 6 months to 1 year before we used to touch anybody. Only when we were convinced that some offense has taken place, then we used to do. And again, during investigation, if something was found that was in favor of the SC, we would drop that part of it. That was one part. Even now, if an SC comes with its hands which are not clean, except we will go to the settlement commission, we'll pay up the bloody dues and forget about challenging it. So that's my principle of practice. Thank you.
To add to what Mr. Patsadi said, I just wanted to just think, the judgment of the Supreme Court in the case of Syed Ali was forgotten within a period of 5 months by everybody because of the Validation Act. But now the Supreme Court has given life to it back again. In fact, if you read the present judgment in the Canoned case, they very heavily rely upon the judgment in the case of Syed Ali, because the department presumed that bringing the amendment into Section 28 by inserting Section 2811, the Syed Ali has been done away with. They have gotten over the judgment of the Supreme Court in the case of Syed Ali. But if you read the present judgment in the Canoned case, the Supreme Court has very categorically relied upon the judgment of Syed Ali to express their opinion in the present case. So a new life has been given to Syed Ali again.
Thank you, Krishna and Mr. Patsadi. May we also request Mr. Chaco, former member, sister, member judicial, who has also joined us today, to share his thoughts.
Thank you, Mr. Natarajan. And first of all, thank you, Mr. Krishnan, for recognizing me. And also welcome, Mr. B.V. Kumar. Nice to see your face, sir. How are you?
Sir. Thank you. I'm fine.
Okay.
Thank you.
Now, I was actually watching and observing the proceedings, and I think I was a lot more benefited by this discussion. Particularly, kudos to Mr. Natarajan for his eloquent and excellent presentation, as he used to do. And that was immediately followed by no less a speech by Mr. Kumar. And Mr. Krishnanand also enlivened the discussion in his own way. Now, at this point of time, I would borrow from Mr. Kumar. He was saying that we have to have a very harmonious construction. I was thinking aloud on that point. Harmonious construction of the legal provisions, that is what is required to sort out this kind of an issue which largely involves the basic interpretation of the various provisions of the Act. First of all, I would like to say that an officer of customs is not a designation. Then proper officer is not a designation. A commissioner of customs is a designation. A deputy commissioner of customs or a joint commissioner of customs, they are all designations. But an officer of customs is not a designation. Section 3 gives a classification of officers of customs. And we can see a hierarchy of designations under Section 3. It is immediately followed by Section 4. Which gives the power of appointment. Earlier, the power was with the government. Now, the power is with the board. And that section says, the board may appoint such persons as thinks fit to be officers of customs. Again, we are coming to the term officers of customs. Who are these officers of customs? Officers of customs, they are all the persons who deal with various or a variety of areas, variety of functions, variety of duties, and a variety of responsibilities conferred on them by the Act, by Parliament. So there are various areas, investigative area, assessment, all these are various areas which fall for discharge of duties by various officers of customs. So section 3 gives a hierarchy of officers of customs. Section 4 says who should appoint officers of customs. When section 4 says the board may appoint officers of customs, inherent in that provision is the assignment of functions also. Now we should read section 4 harmoniously with the section 5. Section 5 says powers of officers of customs. It says subject to such conditions and limitations, etc., etc., the board may impose an officer of customs. An officer of customs may exercise the powers and discharge the duties conferred or imposed on him under this act. Who is the authority conferring this authority on the officer of customs? Or who is the authority who is imposing, who is assigning functions to the officers of customs? And that authority is under section 4. So 4 and 5 should be read together and interpreted harmoniously. And as Mr. Krishnanand was just highlighting, proper officer is the officer on whom the relevant function has been conferred, the relevant authority has been assigned. He is the proper officer. Therefore, I would beg to differ with Mr. Natarajan on this definition, proper officer. Section 2, clause 34 is only a defining provision. Who is a proper officer has been clarified under section 234. But who is the proper officer? Is that officer who has been given the particular power which is in question, or to whom the particular function in question has been assigned. That officer has to be identified from the notification or other instrument issued by the board under sections 4 and 5. So I am of the firm view that a proper officer has to be identified with reference to a given authority or function. A proper officer has to be identified with reference to the notification or other instrument issued by the board under sections 4 and 5. And that officer is the proper officer. Now coming to section 6, there also I would like to differ with Mr. Natarajan. Section 6, I would tend to support Mr. Venkatraman, because section 6 is just an entrustment function to an officer of the central government or the state government or the local body. Entrustment of the function which otherwise would have been exercised by an officer of customs to an extraneous officer, in the sense an officer outside the Department of Customs. That is, any officer of central government or of state government or local authority, an officer who is otherwise extraneous to customs functions under the Customs Act. So entrustment, the word entrust has to be understood in that light. This is what I feel personally.
So
on that particular point, sorry, I am differing with Mr. Natarajan.
No, sir.
Anyway,
on this I am also with you.
all of you
I am also
for giving me
you.
this opportunity.
Thank you
very much.
Namaste, Chako sir. I'm so happy to see you on the screen and take your best wishes. It was a Venkatraman here. Thank you. Nice. Nataraj, can I have 1 minute? No, not a rejoiner. I want to learn from Krishnanand one point, free of cost.
Yes, sir.
Sir.
See, Krishna, I have only one doubt, Krishna. You can clarify if I'm wrong.
Sir.
See, if you today, irrespective of whether it is 3, 4, 6 or 234, if somebody is notified as a proper officer for a particular function, can you invalidate saying that you should have done it in a different section? I'm just putting a very vanilla question. If there is a notification in place describing that function to that officer, tracing it to a different section, will it vitiate or invalidate or nullify that notification is one question, number one. And number two, this is possible in all tax enactments, especially in income tax and all. Income tax, finally, an assessment is passed by a particular officer for the assessment year. Whereas here, assessment is a momentary action. Unlike, there is nothing called in excise or in customs, an annual assessment. So, if functions are scattered to multiple officers, there is no empirical data from 2011 to 2021 based on Syed Ali that the concern expressed by the Delhi High Court in Mangale that it results in chaos. No empirical, in the absence of an empirical data being presented to the Supreme Court, that this is chaotic. If multiple functions are performed by multiple officers, because it is only momentary as far as customs is concerned, unlike income tax, then how do you read the expression the proper officer, one who performs the functions rather than the one person who gets designated? These are the two questions they asked just to learn from you, not to contradict you. Don't worry.
I think the answer to Sir's first question lies in the judgment of the Supreme Court itself. If Natarajan can just display para 21 of the judgment, is it possible?
Yeah, I'll do that.
Para 21. On 20 and 21.
Which judgment? Canon.
Canon.
1 minute.
20 and 21.
I'll do that. Yes. 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 Are you able to see?
No, it's not on the screen. If others can see it, then I can just read what I have.
Others can see that screen share.
No. Can I read it for your benefit,
No,
Mr.
I have it. I can read it.
Yeah, I have screen share is there.
You have not clicked, Natarajan, you have not clicked that Canon India. Click it.
1 minute.
Yes. Raman sir. Just above para 20. It says definitions. In this act, unless the context otherwise requires, proper officer in relation to any functions to be performed under this act means the officer of customs who is assigned those functions by the board or the principal commissioner or commissioner of customs. Section 6 is the only section which provides for entrustment of functions of a customs officer on other officers of the central or state government or local authority. It reads as follows. Can you scroll down a little?
Yes. Whether the screen sharing is visible now?
Yes.
Yeah.
If it was intended that the officers of the Directorate of Revenue Intelligence who are officers of central government should be entrusted with functions of the customs officers, it was imperative that the central government should have done so in exercise of power under Section 6 of the Act. The reason why such a power is conferred on the central government is obvious, and that is because the central government is the authority which appoints both the officers of the Directorate of Revenue Intelligence, which is set up under the notification dated 4/5/1957, issued by the Ministry of Finance, and custom officers.
Krishna, I got the point. Krishna, I got the point. You are saying that it is done by central government and not by the board.
No. You read the last line. The notification is obviously invalid, having been issued by an authority which had no power to do so in purported exercise of powers under a section which does not cover any such power.
I got it. So you are saying
exactly what Mr. Chacko said. 234 does not confer any power to entrust functions.
I mean, if there is an agreement that Section 6 is not traceable, is not the source, then what happens? I'm only asking that.
This is what Mr. Chacko just explained. You have to read Section 4 and 5 harmoniously to trace the powers.
Correct. So there is a source of power. Now, Section 6 is not, I'm just putting it just for understanding, not for debating, please. because it's very, very enlightening to listen to this
for the
lecture.
second question. Now for the second question.
On first question, suppose you diverse section 6. Section 6 is entrustment may not apply. That's one possible view. Assuming that,
Yes.
then within 3, 4, 5, and 234, under any one of these sections, suppose you issue a notification. How? Because the final test is competence.
Yes.
The authority who has issued the notification, does that authority have power under the Act? Under 6 government. So if the case is rested on 6, this challenge is there. I agree. Suppose 6 is got over, then when the power is only with the board, then how does it matter whether it is issued under 3 or 4 or 5 or 234? As long as the authority exercising the power has the power.
Then
competence.
Again, please read 234. 234 uses the word means the officer of customs who is assigned those functions by the board, or the principal commissioner of customs or commissioner of customs. Now, to elaborate it in a very simpler manner, sir is aware with central excise, income tax, and customs, and you know that there are now there are 8 commissioners in the custom house, all of them having concurrent, all of them having the same power, all of them are commissioners of customs. But that would not ipso facto mean that one commissioner who is assigned the powers of assessment of bills of entry, the other commissioner can enter into his domain. It is only that commissioner who is assigned for assessment of goods alone who can exercise the powers, and he alone can devolve his powers to an officer below him. The other commissioners cannot give that power to any other officers working under them. So in income tax, there are various assessment circles in Chennai. An assessee in a particular assessment circle has to get his accounts assessed by that particular circle alone. Any officer of any other circle cannot assess my account.
Therefore, certainly. That's a matter of administrative convenience. Okay, fine. I got it. Now, what is the answer for the second question?
This was my answer for the second question. Also.
The proper officer. Okay, right. Hey, thank you so much.
Is Mr. Sundareswaran, the counsel for DRI, he's available? So if he's available, we would like to hear his views also. Mr. Sundareswaran? Vishwanathan, sir? Vishwanathan, sir?
Yes. Thanks for the opportunity. Whatever limited knowledge with which I am going to speak to you, my first reaction to this particular judgment is because DRI interfered with the functions of an assessment by a proper officer extending a notification where they have no role. The basic judgment has gone by this theory that the power of review is not available with the DRI officers. That is the basic mindset of the judges who have delivered this judgment, in my humble opinion, that the power of review is not available to the DRI officers of the functions of assessment carried out by an officer already who is the proper officer of customs and who is entrusted with the functions of assessment. That is my first view. Second view is, see, there are judgments of Supreme Court, if I am right, Bawa Chemicals, where the Honorable Supreme Court has said that anybody can initiate the process of proceedings by a show cause notice. There was a question that arose in that case, whether an inspector of central excise is authorized to issue a show cause notice for the extended period of time under 11A proviso. Supreme Court said, we are not concerned with the person who initiates the show cause notice, and it is the person who decides the case is what is required to be considered. Here, what is the problem is under 28.1 as well as 28.8, proper officer has been named. The DRI issues the show cause notice and they decide the show cause notice also after having done the investigation, which according to me, even under the general principles of law, it cannot be accepted so. And to what Mr. Venkataraman has just questioned on section 6, it seems that the Supreme Court has taken the DRI officers as a separate appointment under section 6, conferring them with the powers of customs officers. They have not taken them as a customs officers appointed originally by the central government. They have been conferred with the powers of the customs officers to be later section 4, you have notified them as customs officers. That seems to be a wrong exercise of powers under Section 4, where you have already exercised the power under Section 6, there should have been a notification issued conferring them the powers of proper officer in the proper sense. And Section 6, as long as you have not notified them, the Supreme Court was of the view that they have no power to issue a show cause notice. It is quite unfortunate because one point that Canoned is saying, that officers of customs means the only assessing officers have to issue the show cause notice. That may not arise in all cases because there are cases of suppression of facts, serious cases of violations and fraud, which is being investigated by the DRI. So they will have to investigate that and they will have to bring the evidence on record. But the question is, what was started initially is the DRI. Only as an investigating agency, they went into all kinds of cases, including assessment cases, issuing of show cause notice, retaining the power of adjudication also, which has caused the DRI today this deadly order, saying that they have no powers at all to issue a show cause notice even. After doing investigation, what the DRI will do, they can't issue show cause notice. According to me, they can either submit an investigation report to the officer of customs who should issue the show cause notice, a draft show cause notice, or at least they should be allowed to issue a show cause notice in cases involving 28(4). They should not interfere in all assessment cases in terms of 28(1) and all that. Then if they interfere like this, they will have to suffer orders like this. Thank you.
Thank you. Thank you. AP Srinivas, over to you.
Any comments, sir, from B.V. Kumar?
No, you're correct. In fact, I personally feel 28 subclause 4 should not have been there in the statute, because once an assessment is done, assuming the assessee is aggrieved, or if the revenue is aggrieved, they have the power of filing an appeal. Why should 28(4) come into the picture? So 24 should be removed from the statute, and that is what is. One second. That is what is giving the DRI an arm to twist the assessees, which is being misused. In many cases, being misused, and that's not correct. Once a proper officer does the assessment, certainly the revenue can go in appeal against that assessment. And what they do is they just slip over it. There are senior officers who are sitting in the either air cargo complex or in the commissionerate. They have no other work. They can see all these things. There's a review section. Let them see the assessment. Let the officer concerned, if assuming the assessee differs, he is supposed to issue an order under section 17(5) or whatever is the section, and they are not issuing even in spite of specific requests being made. So in other words, both in the field as well as in the DRI, the provisions are not being implemented as they are. And I personally feel 28(4) is causing all the headaches which the DRI is misusing. Thank you.
I may not agree in all cases, sir. There may be a serious separation with declaration and all that. But 129D, when there is a power of review available after assessment to the authority, they should exercise that power under 129D, or they must establish a case of separation for issue of a show cause notice. These functions cannot be abdicated to somebody else. The assessing officer has to only do it. Like in the case of an assessee claiming a refund, the Supreme Court has come heavily saying that unless you challenge the assessment, you have no right to file a refund claim.
Correct.
Similarly, should the officer also be told, unless you review that assessment order, you have no right to issue further notice to me.
Correct.
Natarajan, may I just, nothing to do with section 28 or the canon judgment, but just because Mr. B.V. Kumar is here, I just wanted to say something.
Hello?
The DRI has now changed completely. As far as you said, you were very fair, and if you did not find any evidence against any SSC, you would drop the case immediately. Today, there is not such a position, and as recently as in November 2020, November or December 2020, the Supreme Court came out with a judgment in the case of Paramveer Singh Saini. I don't know whether you have an occasion to go through that particular judgment. In that particular judgment, they fall back on the D.K. Basu case, where procedures are prescribed for interrogation. Now, with a heavy heart, I have to say that the Supreme Court listed out nine agencies. Of course, leading the head was the CBI, and DRI is also one of the agencies specifically notified, specifically mentioned in the Supreme Court's judgment. And in the end, it is said that any department with the power to interrogate and the power to arrest, they shall do such interrogation only under CCTV supervision with recording facility. Now, if the Supreme Court has to take such a view in a judgment of theirs and directed the departments and all these agencies to file an affidavit before the court that we are completely covered by CCTV with recording facility, human rights are being violated, the person who is interrogated has a right to ask for the CCTV footage so that he can move the Human Rights Commission against the violations. So this is the difference between when you were in the DRI and what the DRI is today. So just for information.
Yeah, no, it's correct.
Sir,
I
I
agree with
fully agree, sir, with what Krishnanand says. What your days were different now, totally different. That's why all these problems are coming up.
Correct, you're right.
I'm obliged.
AP Srinivas?
Yes, sir. Yes, sir. So, in my view, the amendment made to section 28 itself is enough, sir. So, there need not to be any further notifications under 6 and all. The 2811 was not properly shown to the Honorable Supreme Court. So, the DRI is having every competency to issue the show cause notice, and further they have been assigned with adjudication power also, but they are not doing. After receiving show cause notice, they are relegating to the relevant adjudicating authority. There, by doing so, the argument canvassed by Dr. Krishnanand by referring to Syed Ali judgment is also taken care. So the another point is, even if they are proper officers, whether are they are empowered with the territorial jurisdiction. That's the point mostly considered in Syed Ali judgment. So by taking note of that only, the DRI is relegating to the concerned adjudicating authority.
I beg to differ. DRI adjudicates 90% of the show cause notices issued by them.
It can be. That's what I say. It can be there. They have adjudicating power. You cannot compare one system of assessment as well as income tax act should be in customs act. So there are cases, many cases, a particular authority can give adjudicating authority over the country also. So that's what DRI is doing. So now you cannot restrict the import to made in Chennai customs. The offense is confined to Chennai customs alone. There are multi-level parties, Goa parties involved, Bombay or Delhi assessees are involved there. So therefore, rightly the DRI is put to take care of such situations. This is a common power over the entire country of India. So they need not, you need not to compare with the proper assessing officer sitting in the customs station alone. So in our view, the 2811 amendment is take care of the entire DRI jurisdiction, sir. It is not properly focused. I think soon it will be re-argued. Our Leonard AAG was also giving his valuable inputs, and we had two more officers, 3 officers from the DRI and the Customs Department. We hope the canon will be reconsidered and the canon will be set forever. We hope so.
All the best. All the best, sir.
The digital still image camera will be set forever. Yes, sir. Thank you all, sir.
But what are you going to do now? All the notice will, so much writ petitions are going to be filed now.
No, sir. Before you bring all those cases, the canon will be set, sir. It's by the same bench. Let us hope so. Sadish Sundar.
APS.
Yes, sir. Yes, sir.
APS, sorry, I couldn't join.
Okay.
Hello.
We were expecting you.
ஆமா நான் கொஞ்சம் வெளிய போயிட்டேன்ப்பா இப்பதான் வந்துட்டு இருக்கேன் கார்ல இருந்தா பேசுறேன்.
You give your views. You are an expert in this subject.
எக்ஸ்பர்ட்லாம் கிடையாது, but I think Syed Ali has been reiterated in canon India.
But overlooking the amendment made to 2811.
2811. That is what. No, actually, this matter should have been tagged along with Mangli
and text batch.
Correct.
Somebody should have brought.
But they don't have competent ASGs there. I don't know.
No. We cannot say like that. It somehow escaped the attention of the Honorable Court. This is the term we use to.
But my view is
escaped attention.
My view is
we will bring it now.
But proper officer definition, what the Supreme Court said, according to me, was
there are so many ways of writing.
There cannot be any other view on proper officer.
Okay. AP Srinivas, already it is 7 o'clock. I think you can declare a formal closure.
Yes, sir.
Sorry, I couldn't join earlier. Thank you.
I wanted to personally thank Ms. Natarajan for inviting me to this wonderful presentation which you made. And for me, it was an education from you, Dr. SK, and many of our learned colleagues, and Mr. Chako also, who very beautifully presented his point of view. Thanks. My thanks to all, including Mr. Satish Sundaram, who joined late. Thank you.
On behalf of Madras Tax Bar, I propose vote of thanks, sir. I thank everyone all present in this session today. And we especially thank Mr. B.V. Kumar and Mr. Chako and other eminent personalities who have assembled today. So we are continuously having webinars, sir. It is our 130th webinar. So we request you to come and participate in our successive webinars also, sir. So today we had a very enlightening session. Our members have enthusiastically participated, and the session went for two more hours, sir. After a very long time, we had a very elaborate.
Only regret is DRI Council did not speak.
No, he is silently watching, sir. Department is silently watching what all are the points we can take it and to reconsider.
All of you do that. All of you do that, you know. You make us talk and you grab it.
Yes, sir. We hope in Mangli impacts the proper judgment will come. We hope so. So in that batch is pending, we'll bring to the attention of the Honorable Court about the amendments made in 2811, and that itself will taken care of the DRI jurisdiction. So once again, I thank one and all, sir. Thank you all.
Thank you. Good night.